This case is horrible. And I mean, I know he says he's pleading to a one-time penetration, but from reading this,
He didn't say that. I said it because
Okay.
I was just talking about the legal
Yeah.
issues with that. So,
but I mean, having a child having her brother lick his butt.
that was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
That's a different one. Yeah.
What is wrong with you?
You may recognize this case, or maybe it's new to you, but we're going to go back and watch the entire hearing, and then we're going to step into some news articles how this case actually affected Judge Boyd and how she's been recused from 3 felony cases amid the fallout of this hearing. I do want to give a special thank you to Meg's Crime Watch. Hopefully, you are familiar with her YouTube channel. If not, check it out and give her the credit that she deserves. I'll put the link in the description below. With that, let's jump to the beginning of this hearing.
The court will find there's sufficient evidence to find you guilty. Court will find you guilty. Is there a reason I should accept this agreement? Why am I accepting this agreement?
Well, Your Honor, in this situation, what he has pled to is a single count of a single time of sexual assault of a child, which is aggravated sexual assault of a child. He has agreed to do this early on in his process. He is not contesting his guilt, and he is not contesting what's going on. He's agreed to go to prison, and 15 years is a substantial amount of time.
State, why should I accept this agreement?
Your Honor, the child is very young. She's in therapy right now. I discussed it with the mother. And this is, there is a desire to get closure early on in this case, Your Honor.
So
At this point, we haven't had to re-traumatize the child by bringing her in and talking to her about this case yet.
this case is horrible. And I mean, I know he says he's pleading to a one-time penetration, but from reading this,
He didn't say that. I said it because
Okay.
I was just talking about the legal issues
Yeah.
with that. So,
but I mean, having a child having her brother lick his butt.
that was something that I think was determined that did not happen.
Well, she says that he asked her to lick his butt.
That's a different one. Yes.
What is wrong with you?
Well, Your Honor, I'm not trying to like beat around the bush. She was showing me her crotch, and that's
And you got turned on.
no, I didn't. I'm telling you, I'm not like physically like. Well, I did get turned on, but not. Well, after a while, she just kept doing that. Tell her not. You know what I mean? Like,
So you blaming a 6-year-old?
I'm
Your
not
Honor-
blaming my
Your
6-year-old.
Honor, if I may, my client was sexually abused when he was a child.
How old is he now?
He's 35 years old now. But the trauma that he suffered as a child has definitely surfaced in a way that is abhorrent. It's in a way that is obviously is not good. And that's why we are here. And he is willing to go to prison, be a lifetime registered sex offender, almost certainly be deported. He'll never live. He's been in this country since he was 2 years old. He will never live in this country again legally. And he will.
So
have to
he's
live
being released to, after he does his time, released to go somewhere else and deal with his trauma that may result in him molesting some other child?
Well, he has, what he is hoping to do is, as you know, the TDCJ system offers a pretty comprehensive sex offender counseling and treatment. And of course, you know, he will at some point be wanting to go on parole. He knows that he's going to have to complete that. To do that, we have talked about it, explained it. He's going to take the opportunity to do that, as well as other programs that are offered in TDCJ. He is motivated to do that, and you know, at some point when he is released, as I said, he's going to go to a country that he has basically never lived in his entire life, which
And
I
what
understand.
country would that be?
Mexico.
They have nice beaches there. So again, we go back to the point, what were you thinking?
Yeah. I can just say sorry, but like the only thing I can tell you is that I didn't like, I try not to hurt her. You know what I mean? Like,
Wait, are you saying that you were molesting her, and as you were molesting her, you were molesting her in such a way because you didn't want her to hurt her?
no, I asked her, you can put this in your mouth. That's it. And she said no. I said, that's fine. Okay, that's it.
No,
Your
this
Honor,
is not, this is a penetration.
Your Honor, if what he has pled to is, and what he confessed to is by penetrating the anus with his finger.
Mhm.
And he had told the police when they asked him that he told the police that he did that at the time, which is another thing. He was honest with the police. He told them what he did. You know, and at this point, we're asking for this because we have agreed early on not to leave this on a docket, not to go through the process, not to have his daughter have to come in and, as the prosecutor said, be traumatized by this, have to come in and talk to prosecutors, have to get the phone call from the DA's office. They want it done. They're going through a divorce. He's never going to have custody of these children. He's lost basically everything, including the country where he grew up, and he's going to lose his freedom for up to 15 years and for a minimum of 7.5. But as the court knows, parole doesn't happen like that for these cases. They're doing 75-85% of their time. And so he's lost his freedom for more than a decade. He has done a horrible thing, and there's nothing that he can say right now that can explain that. I think the court's questions of him, how he has confessed to you and now that he has done it. And what
No, he pled no contest.
He pled no contest because I advised it, because there's a civil case going on, but that's a legal advice that he was getting from his lawyer.
Yeah, so I mean, I understand, but he pled no contest. So again, we're back to what were you thinking? Because I'm trying to figure out where you're coming from to figure out whether I should follow this plea or not.
sorry, Your Honor, I didn't do it. I didn't do it to like hurt my daughter. I tried, I'm begging and telling you, please, I'm telling you, please. I'm not trying to force my hand in her vagina or in her ass. I basically grabbed her and I put my finger where it shouldn't be. That's it. Like I can't, I don't know how to explain.
No, so
it.
the way you're explaining it to me, you're making it seem like it was an accident.
No, it wasn't an.
So was it an accident or not? Because you're telling me you just grabbed her and you're making it seem like your finger just accidentally penetrated the
The
anus.
thing is, I just don't know what she wants. Like, she's spreading her legs at me. Like, what do you want me to do? And like, she's spreading her whole vagina at me, like at least 4 or 5 times. Dropping her pants, like literally. Like, it's not like I'm telling you like my actions were right.
I know, I'm just trying to figure out where you are mentally, and yes.
So if I grab my daughter's butt and I throw her on the bed and I didn't like forcefully sleep.
Your Honor, at the time he told police officers that he had put his finger inside of her anus.
So it wasn't accidental. Am I right in assuming that?
He did not tell the police officers it was accidental. I don't think that he's trying to communicate that to the court. We are asking the court to follow this plea bargain. It is obvious that the man has sexual deviancy, and it's obvious all of those things that we have for people who are charged and people who are convicted of this. All of those things we're doing here. He's going to the penitentiary. He's going to be a registered sex offender for the rest of his life. All of those things are what's happening in this situation for people who have this apparent or this abhorrent behavior. He's obviously injured this child, and he understands that. He's signing for 15 years to go to prison because of what he's done.
All right, so this is a life case, honestly. So State, you want to explain to me why the court should follow this 15 years?
Your Honor, this was done, having been in this position, I have seen these cases that languish for 4, 5, 6 years. And I had discussion with the mother. And the benefit of the child was to get this done, have no right to appeal, so the child could move on. It's up to the court's discretion. I'm happy to reconfer with defense counsel as well on this.
All right. If you all want to reconfer, the court would be willing to accept a plea of 20 years, not 15. If you all want to reconfer on that, you can.
Okay.
Or, all right.
Your Honor, two things. I'm set in jury trial in County Court 13. They're starting to pick the jury now.
Oh, tell them you're in felony court. I'll call County Court 13.
It's Judge Skinner. It's County Court 13 impact.
I'll call them. So if you all want to confer and see if he's willing to accept 20 years.
I can't talk to my client about something like this in the matter of a few minutes. I mean, this is something that we just asked for a reset. If that's what the court is asking us to do, it puts too much pressure on the attorney-client relationship for me to talk to him in the box about a complete reworking of this plea bargain. I spent hours with him in the jail, going over discovery, doing all this stuff, and this is I'm asking for a new setting.
All right, Ms. Ferguson, recall this for tomorrow.
And if I'm in jury trial
Oh, tell 13, you need to be here tomorrow.
and have her jury wait.
Yes. This is district court. So I'll see you all tomorrow. Diaz Hernandez.
Man, I love Judge Boyd. Yeah, it's, before I unpack it and share my thoughts, let's jump forward. It didn't end up happening on Friday. It ended up happening on Monday. So let's go see if what the outcome is.
Counsel, did you complete your trial? How did that go?
I did.
Okay.
I quit.
Oh, well, congratulations. Oh, yes.
Yes, complete on Friday.
Okay.
On this case,
Mhm.
Judge, the last we were here, the court declined to follow the plea,
Mhm.
offered the client 20 years.
Mhm.
We are respectfully, we have given the court reporter payment for the record, and we are going to respectfully file a motion to disqualify the court in this proceeding.
Okay.
So,
So is your client not accepting the 20 years?
my client is not accepting the 20 years as it's been offered by the court.
All right. All right. Ms. Ferguson, can you put this on the jury trial docket, please?
Your Honor, I've been informed that it will take 4 days for the record, including this one. And so,
Well, whatever date, the first date of jury trial, that's the date of jury trial.
understood.
Okay.
Thank you. Oh, Your Honor, may we put this on the record?
Oh, after the coordinator comes in for
Yes,
jury trial night?
yes.
Hi, Ms. Ferguson, on this case, I need a first jury trial available for this case. All right. All right, court is calling 2000. All right, court is calling 2023 CR 0543, State of Texas versus WILBERTH VILLAMIL. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Jason Goss for Mr. Villamil.
All right, we were here on July 6th for a plea. The court would not accept the plea. The court informed both parties that the court would accept a plea of 20 years. Defense?
Yes, Your Honor, we wanted to respectfully inform the court that if our intent is to file a motion to disqualify the court from this proceeding, And that at this time, the court's offer of 20 years to the client is rejecting because we are waiting for that motion. We have tendered a check to the court reporter in order to get the record. And then once that record is received, we'll file the motion and we can go along that process.
All right. Well, your plea deadline date has expired, so the court will not accept any plea bargain agreements in this case. Your jury trial is set for August 8th. And whenever the court reporter is finished with the record, the reporter will be able to give that to you. I do know that there's a backlog, the records that she has from out of Houston and for the fourth court.
Yes, sir.
All right. Is there anything else?
No.
All right. Thank you. See you back on August 8th for a jury trial. Ms. Ferguson, can you give them a jury trial reset, please?
Well, the trial date never happened. It never happened because this defense attorney filed to recuse the judge. And because, here we'll go into it, because the defense attorney complained that the YouTube commenters made disparaging comments about them and their clients. Oh my gosh, I can't believe it. People made disparaging comments about this sick monster. That's what's wrong. That's what's wrong with the result of this. You know, it's wrong that the judge wanted him to serve 20 years versus 15 because we, the people, made disparaging comments. You can't make it up, right? Here it is. The San Antonio, an administrative judge this month granted recusals in 3 felony cases being heard in the 187th District Court. Judge Stephanie Boyd, following complaints about her decision to stream courtroom proceedings on her YouTube page. You know, if this is not an effort for them to hide how broken the system is, and I'm not sure what is, right? Are you kidding me? I wonder what the next step is, huh? Are they going to try to make these proceedings? Are they going to try to bring them back behind closed doors so that we, the people, don't see how broken the system is? So that we, the people, don't see the little sentences that they try to hand out to these disgusting monsters? The recusal granted by visiting judge Sid Harley will move future proceedings in an injury to a child causing seriously bodily injury case and 2 indecency with the child cases out of Judge Boyd's courtroom. Records obtained by KSAT investigate show, right? So she didn't only lose this case, she lost 2 other cases. The recusals come amid continued fallout from Judge Boyd allowing viewers of her courtroom's YouTube page to comment in real time while proceedings are taking place. And what they're talking about is the live chat, you know, on YouTube. Now, defense attorneys have complained to KSAT in at least one formal complaint that the State Commission on Judicial Conduct that Judge Boyd's enabling commenters has subjected them and their clients to targeted with abuse and disparaging remarks by people watching online. Poor guy, huh? He has to suffer the abuse of people commenting in the live chat about what he's done to his 6-year-old daughter. She was opening her legs. What was I supposed to do? You can't make it up. This is a life case, as Judge Boyd said, and he should have gotten life. This case is horrible. A complaint against Judge Boyd's file with the State Commission on Judicial Conduct earlier this year described as July 6th hearing for a sexual assault defendant. The defendant, WILBERTH VILLAMIL, who was scheduled to plead no contest in front of Judge Boyd to a single count of aggravated sexual assault with a child in exchange for 15 years in prison. Instead, he saw his case delayed and then transferred to a different court. Is there a reason I should accept this agreement? Why am I accepting this agreement? Which is such a clear and obvious question to anyone, I believe, with some common sense that cares about children would ask. Commenters on the stream, which had been watched more than 8,500 times as of Thursday, described the defendant as sick, wrote other insults about him, wrote other insults. Yeah, okay. And wrote that he deserved longer than 15 years in prison than the plea hearing took place. And can anyone sit here with a straight face and say he doesn't? No, it's simply his defense attorney, which of course he's doing what a defense attorney does, and the assistant district attorney, which I'll get to her in a moment. This case is horrible, said Judge Boyd as she weighed in whether to accept the plea agreement. The prosecutor assigned to the case said that the deal was offered because the family of the victim wanted closure and not to re-traumatize the victim. And we'll get to that in a minute. Judge Boyd, after hearing VILLAMIL describe the sexual assault, said the court will be willing to accept a plea deal of 20 years, not 15. The attorney then said it would not be appropriate to discuss complete reworking of the deal in such a rushed manner, and the case should be subsequently reset. Now, the case was then transferred to 227 District Court, where he pleaded no contest, and on August 24th, he was sentenced to the original 15 years. The formal complaint against Judge Boyd states that she violated several of Canada's Texas Code of Judicial Conduct with her statements made during the live stream. So her statements saying what's wrong with you violated the Code of Judicial Conduct. The commission has not indicated if and when it plans to rule on the merits of the complaint. Judge Boyd told KSAT via email this week that we had contacted her about the matter under seal. While my goal is to have a courtroom which is transparent, I cannot nor should anyone else comment on matters filed under seal, wrote Judge Boyd. It says that she has 14,600 subscribers as of Thursday. And this is as of Thursday when this is written in November 30th. So I'm surprised she has that few subscribers because she is one of the better judges that we have seen. And what she was doing is, now let me just get to my comments. And again, I want to give, please to check out a very good channel, which I've only recently have found, but I've found to really enjoy it because she puts in a lot of work. There's a lot of channels that just repost content, but Meg's Crime Watch, she actually puts in work. She shares detailed information about the law, and you could see she works really hard and she does a great job. So please check her out. I'll put the link in the description below. And then also, of course, big shout out to Richard, who helped with some of the research of this case. Now, here's a few things that we need to note to before we can, I guess, maybe address what the district attorney, the prosecutor, the assistant district attorney was stating, which is the words that she uses. She said, "I had a conversation with the victim's mother." They just want to move on. Now, do you think that that's really enough to understand, first of all, whether or not you should prosecute this to the fullest because she had a conversation? She had one conversation. Shouldn't we maybe get into the room, everyone who is involved in this case, in terms of child services? Should we understand who the mother is, how culpable she is or is not, what type of situation is in the household, before you just go ahead and say, you know what, let's just move forward with the plea deal? Second, does the mother understand that this monster is going to be up for parole in 2030, April 28th, 2030? That's his parole eligibility date. That's in 6 years from now. The victim's going to be 12 years old. What's going to happen then when you have to get up in front of the parole board? So you're kicking the ball down the road for 6 years because at some point she is going to, unless he just gets out, of course, she doesn't have to testify at his parole hearing. but she's going to be made aware that he's up for parole. You know, if this was the point that I'm getting at is that we have covered on Mandy channel, my main channel, over 1,000 cases. We have covered hundreds of cases where a child is hurt by their own parent or by their own very close relative or by some other adult. And we have seen many times where the ADA gets up and says something like, for the sake of the child, we just want to move ahead with this. And we have seen many times where that was completely not true. It was false. They are saying it because they don't want to go to court. They are saying it because their dockets are full. They just want to get it off of the docket and they want to move forward. In some cases, they're saying it because trials can be messy. Things can go very wrong. We have seen it. But at what point do you have to say to protect other children, maybe you just have to go to trial? You know, if this was a case where he had taken a life of someone, and now the question is, well, do we do a 15-year plea deal or do we go to trial because he should get sentenced to life? It wouldn't even be a question. They would say, of course, you go to trial. What do you mean the child has to testify? The child's going to testify. So much so that even if it wasn't taking a life, if it was something like robbing a bank, oh, they'd go to trial for that. But again, when it comes to a child, they don't care. We saw this hearing. We saw him literally claim, what was he supposed to do? I didn't do it to hurt her. I mean, I didn't know what she wants. She was literally spreading her legs open at me. That's what he tells a judge. That's what he thinks. You're going to kick the ball down the road and then send him back so that he can harm more children? You know, it was like so clear to Judge Boy. She's like, wait, so you just want to send them into Mexico to do that to kids there? Well, why? It is like anyone, I feel, with a common sense would look at this and just want to scream at the screen and say, how is this possible? How is this possible that the person who kind of gets punished is the judge who wants to protect our children? And the people that don't really care that much, the ADA, who says, well, you know, we just, it's a big punishment. 15 years is pretty big punishment. I mean, can you imagine being a defense attorney for this case? I get that defense attorneys need to exist. It's a very special part of our system. Could you imagine, though, if this did go to trial? Was he going to continue to represent him? He already heard his client admit to it. He already heard his client state those words. Well, what was I supposed to do? How could he have, with good conscience, then represented him as a defense attorney and then question the victim on the stand, the 6-year-old girl? What would your approach been in a trial case? What would it have been? Because if this wasn't overturned, he would have lost his opportunity for appeal. It would have gone to trial. Would you then stand there and make up a whole case how it didn't happen, how the 6-year-old lied, when you know for certain that it did happen? How could you, in that case, see, there's one thing if you're a defense attorney and your client says, I didn't do it. You have to convince yourself that the client's being honest with you and then given the best defense possible. But if you know your defense is lying because you already seen him admit to doing it, how would he have gone to trial there? But I personally I think any defense attorney that would fight for a client that does this to his own daughter and not just recuse himself from the case is in itself a problem. I mean, how can you live with yourself? There's something very wrong with the system when you can do this to a child, to your own daughter, and they consider it a good day in the justice system when they agree to 15 years with parole eligibility after 6. You're kicking the ball down the road. It's a slap on the wrist. You're altering the life of a child, of really children in this case. And he can be out in 6 years. Not to mention what he did to his son, what he had his son do to his daughter. I mean, just the idea that the DA only wanted to even give him one charge, it just shows that they don't care. You could have slapped him with dozens of charges. One charge? We live in an upside down world. And that's why it's so important to show these cases, because that's the only thing that can potentially lead to change one day. And the idea that really, I feel that what was right lost in this case, what was purely good lost, and what was evil won is just a scary day, a sad day. With that, I'll let you go.